invite my panel up. And I'm really excited because they are so experienced. And so come on up, both of you. I have Merv, who is an estate attorney, and Megan, who's a fiduciary. And I'm going to have both of them take a moment. So you guys go ahead and grab a seat, whichever one falls to you. And when we're talking, I should share this when we were back there, but the microphones, when the button's green, that means it's on. When we're not talking, we turn it off. You want to have this fairly close. Rick, I'm going to have them test it. I had the community was supposed to test it, but mine was so loud. Will each of you say test on yours? Testing? That seems right.
Test.
Okay, I think we're good. Okay, Megan, would you stand up? Megan is a fiduciary, and I'd like each of you to take a moment and share your background, your experience, what made you specialize in this, and what's your unique approach of philosophy or strategy? Oh, wait, one more thing. Okay, I'm sorry to interrupt you. You guys, you have to be really kind to Megan. This is her first time on stage. She's very nervous. And she's a wealth of information. I wanted a fiduciary, and the one we were going to ask didn't want to do this. And I happened to meet Megan online and heard about her past, and I was so excited. I was so glad she said yes. And so please welcome her, and it's like make her feel comfortable.
Thank you, Christine. Wow, it's really, really nerving to see everyone out here, and you all look very happy to see everyone up here. My first trust, first of all, I am a licensed California fiduciary. I've done training, and I've had a lot of background leading up to what I do today. My first trust was actually for my own father back in 2001. We found out he was really sick, and he did not have a trust yet. And my sisters, I was the oldest of 3 daughters, and my sisters and I, decided one of us needed to be a trustee and get a trust installed and in place for my dad. So I was his trustee and his power of attorney and his healthcare advocate. And that was my first trust, and it went really smooth. And now when I look back on it, I thought, I have no idea what I was doing. Thank goodness I had a good CPA and an attorney who would help me through it. Years later, while I was working, I was an executive assistant working for a real estate developer here locally in Encinitas, actually. And his mom had some issues and some needs. She was living alone, and he did not have time to spend a lot of time with her with his business. So he put me in charge of his mom and said, she's got your number, call her once or twice, a month, and just check in and see if she needs anything. And I would go over and I would take her shopping for a new pair of shoes or whatever. And that was my first engagement with working with a senior. And I really, other than my own dad, of course, and I really liked the feeling of helping. And it brought back a lot of memories because I used to help a lot when I was a kid. My mom was really sick, so I learned from this age how to help people. Help my sisters, help my dad, help my mom, vacuum dust, all that. So it was while I was working with my boss's mom that I learned to understand and know what seniors need and wanted. And years later, the business was going away, and I was looking for something to do, and I did not want to work in a regular job anymore. So I decided to start my own little personal assistant business. And I literally put flyers on bulletin boards advertising my services, mainly to seniors, and it involved bill pay, helping with insurances if they were having trouble, taking them to doctor's appointments, communicating with family who were not nearby and sending emails like, here's what happened at this doctor's appointment, I think you should reach out to the doctor, they have questions of the family. That kind of stuff. And I kind of built my own little business that way, and it was a word of mouth business. I did not do any advertising. I was not on the internet. And slowly, I had my own little business, and I had really happy seniors that I loved so much. And at one point, it was around 2016, a friend of mine said, I think you need to meet somebody that I know, and she's a really good friend of mine, and she is a fiduciary. I said, what is a fiduciary? And she goes, well, actually, she does a lot of what you do, but she also manages money, and she goes, well, I'm gonna let you talk to her. And I did, I met with her, and she invited me into the office, and she said, I know that you have your own business. She goes, but we don't have somebody to fill this little position in the office, and it's whenever you want to come in, you can just come in and, help out in the office, and I'll pay you. I said, okay. And I said, no schedule? And she goes, no, just come in and you can do some accounting, and you can learn some accounting, you can, answer the phone if it rings, you can do some filing.
And how many years did you do that?
I did that for about 2 years. And about 2 years after I was there, one of the other fiduciaries in the office needed an assistant dedicated just to him. So I started doing more of what I was doing and getting more involved.
And at what point did you get your license?
2021, I started taking classes, and 2012, actually during the pandemic, I started looking into it and became licensed in early 2022, so I'm going on my 3rd year license in California.
That's
Love
awesome.
it every day. It's been a joy. I go into the office every day and love what I do. Every day is different, and I'm excited to be doing what I'm doing.
That's a wonderful.
Everything I've done has led up to where I'm doing today.
Yeah, it's like a roadmap to it.
Exactly.
Thank you. Yeah. Mark, will you share a bit about yourself?
I would be delighted. Okay. So I'm an attorney, estate planning, elder law attorneys, and those are two different things. And I got into each a little bit differently. So, the first one was, how did I get into estate planning? So, and I've been doing that for 40 plus years, I guess. I was doing real estate law. I hated litigation, but I was doing real estate law, which to me meant the neighbor had his fence post on a half-inch over, it was garbage cases, really. I hope no one has that. I'm not calling that case a garbage case, but nevertheless, to me it was a garbage case. And a friend of mine, a financial advisor, called me up, and he said, Merv, I'm reading this magazine for financial advisors, and there's an attorney up in San Francisco who's advertising to financial advisors to bring their clients in. Why don't we go fly on up there? You go incognito as my assistant, and we'll see what he's doing. We'll see what his game is. So we flew on up there and met with him, and he was pitching to financial advisors to bring their clients in. And by the way, I'll pay you, $150 if you put together an asset schedule, because that saves me time or whatever. And it's probably legal to do that. Okay. So then we went up to his cabin in Lake Tahoe to put together a 5-year plan. Now, his cabin was a Taj Mahal, but that's a separate question. Okay. And that's how I got into estate planning. And I enjoy working with nice people and helping nice people, and that allowed me to do it, and it allowed me not to have to be in court litigating about whether your fence post is a half-inch over or not. The other thing I got into was elder law, and 20 years later, same guy calls me up, and he says, how would you like to help veterans? Well, my son had just got into the Army at that time, so, it was kind of on my mind, and I said, well, yeah, that sounds good. So we're going to get veterans their benefits, right? If they need a monthly pension, we're going to help them get that, because the VA has something called a pension. You all call it aid and attendance, but it's a visual aids pension. And we flew out to Phoenix to get training basically by some insurance agent because there was nothing, no lawyers were doing it. We were 3-4 years ahead of everybody else. And we came back and we started doing that, and we did presentations such as this at assisted living facilities, that type of thing for the children to come on out and take a look at how they could help mom and dad. And again, it allowed me to help nice families without having to get involved with the court system on litigation. I've been in court many times, but litigation is not my game. So that's how I got into it. What else did you ask me? It's been so long ago, I forgot what the question was.
So do you have any unique approach that you like?
Unique approach that I like, yeah. So I do not shoot from the hip. I never shoot from the hip. So when a client is talking to me and says, so how do we solve that problem? My comment is, I don't want to give you a shoot from the hip solution. I want you to have top-notch solutions. So let's put together a plan. Having a plan is always better than just going out and doing, in this case, wasting the client's money. So that's my unique approach. We take it step by step by step. I'll put together some kind of analysis with alternatives and my recommendation, and what each is going to cost and that type of thing. And the client says, well, I liked one and I liked two. Can we combine those? And we figure it out that way. And we create a plan and then we go forward from there. So I would call that my unique approach. The other one is I follow up with clients. I constantly follow up with clients. I don't just, here it is, be gone. So, no, that's my unique approach. Was that it?
Megan, do you have a unique approach? Anything you can think of? I know that was like throwing a curveball here.
Yeah, I think my unique approach is just treating everyone with kindness and care, because we don't know where everybody's coming from at the time, and especially, in a situation where there are beneficiaries involved, many of them are very sad and going, through a grieving process. So I think just treating people with kindness and care, that's kind of what I've been known for.
Okay, thank you. Thanks for the introductions. So let's get into the meat of the matter. That's why the folks are here. Let's get into trust. So Merv, let's start with you. What are the main benefits of setting up a trust versus having a will from a management perspective?
Okay, well, I'm going to leave out from a management
Okay,
perspective,
that's
because
fine.
that gets us into something else. But
Okay.
let's just talk about living trust. That's the term you all use. So let's use that term. There are a lot of myths about living trust. I actually wrote an article about that, 5 biggest myths or something like that. Because everything that you can do with a trust, you can do by other means. You can avoid probate by other means. You can avoid conservatorship by other means. You can do all. I don't want to
Go ahead, please do.
You can do all of these things by other means, okay? But the benefit of a trust is you can do more than one thing at the same time. So, for instance, you got a $500,000 bank account. You want to avoid probate on it when you die for the benefit of the kids. So you go get a living trust. Valid approach, okay? Well, you could do that with just putting POD on the account. Pay on death for my kid. You can do that. But what happens if your kid dies before you do? Well, you want it to go to his kids. Or you want it to go to his sister. Let's say that's a better example. You want it to go to his sister. You can't do that on a POD account, but you can with a trust. Okay? What happens if you have a stroke and you can't communicate, you can't take care of yourself, and you don't want a court conservatorship established? You can't do that by a POD account, but you can by a trust. So a trust can do a lot of things at the same time, but any one of those things can typically be done by something else. Okay? So what are we talking about? We're talking about avoiding conservatorship, which I mentioned. We're talking about avoiding probate. We're talking about having, I don't want to say complex, but a slightly more complex distribution than just to my kid or just to my 2 kids, or very complex. You can have a trust continue to the kids. It's probably a bunch of other stuff. Privacy, some people tout that. If you don't have a trust, you die, you have to go through probate. There is a inventory and an appraisal that gets filed with court, which is generally public record, so everybody can see what you had Okay, you're dead. I don't know, how important that is to me. I'm gone. If you know what I have, I can probably, I was going to say live with it, but I couldn't because I'm gone, right? So, I don't know, that's a big deal. I guess it might be to those who inherit, because of scammers and whatever, they could look at that, but, I don't know how important that is. That's an individual thing. What else? I'm sure there's other things. But anyway, that would be it. Now, from a management standpoint, which you commented on, a trust can be beneficial during life, whereas a will, of course, only takes effect when you die. A will, in case you don't know, I suspect everybody knows, directs how your assets will be distributed. Who will inherit them? My kid will inherit everything. My kid will inherit the house. My daughter will inherit the bank account, whatever it is. But management can mean a couple of things. So if you have a stroke, you're still alive, you can't handle your financial affairs. Let's make that assumption, because people can have strokes and can still do that, but not all people can. Of course, not all people who don't have a stroke can manage their money either, so that's probably true too. But in any case, so you don't have to have a stroke to use this feature, I guess that's what I'm saying. You can have someone else come in, your firm, trust company, whatever it might be, your kid, and have the legal authority to manage your assets for you, in how it's invested, how much will be distributed, that type of thing, pay the bills. So you can do that. The other thing that is beneficial, although it can be done in other ways, I've seen a number of clients who will have, I was talking about this on Friday, with 36 assets at 52 different financial institutions, something like that. I'm sure I'm exaggerating slightly, but only slightly. But a lot of people have 4 or 5 different stockbrokers, right? And I'll have an account with each one of these stockbrokers because I'm going to get different advice and different ideas. And of course, if you take a look at what they're invested in, they're probably invested in very similar stuff, right? Very similar stuff, because all of these guys, to a large extent, invest by the same concept, which is called asset allocation, really. But in any case, when the person dies, now you got to go around to all these different financial institutions to get control of those assets. You got to figure out what they are. How much was there? Did anything disappear surreptitiously? Happens, not often, but it does happen. So if you want to make it easy on your kids, you have it under one financial institution umbrella, or 2 at the most. So, with a trust, that's maybe a little bit easier to do than without a trust.
So you had said that living trust, is there different types of trusts, or are they all just a trust?
Or are they all just a trust? Okay. So we can divide them up by different means. So you have revocable trust. It can be changed at any time, right? And that's what I call your garden variety living trust. You just call it a living trust, or a family trust, or a trust. And then you can have irrevocable trust. Cannot be changed. Okay, so why would you use an irrevocable trust? Typically, we do it for 3 reasons. Certain types of tax benefits, generally coupled with some kind of charitable donation involved, some kind of future charitable donation involved, so you get a tax deduction now. We might do it for creditor protection, lawsuit protection, and we might do it for government benefits like Medi-Cal or veterans benefits. So those would be the 3 areas where we would typically use an irrevocable trust. It's highly unlikely that we'd use it anywhere else, although I've seen it when clients have come in. I've seen them with an irrevocable trust, and I can't figure out why they have it. And of course, if you ask, it's, I don't know, the attorney said to do that. But I'm sure my clients say that too, but I could not figure out why they had it. So that's usually how we divide trusts up.
Okay, one more question. So there's all these terms. You hear trustee, trustor, executor, fiduciary. I mean, it's just like alphabet soup. Could you explain a little bit about what's what?
Yeah, let's just use one alphabet soup. M for manager. They're all manager, okay? Executor has to do with probate. Administrator has to do with probate. Trustee, you're not in probate. holder of the power of attorney in fact, same thing. Takes care of assets that aren't in a living trust for you, but a manager. So I mean, I get rid of all of that. I just tell the client, it's the manager. That's what it is, manager. Forget about all these names, who cares? Was there one in this, or is that all?
Fiduciary.
Fiduciary is a little bit different. So fiduciary, another term for that oftentimes is trustee. And we were just talking about that earlier before the meeting started. And actually, you had a great definition for it, so why don't you chime in?
Megan's turn.
And you are a fiduciary, so your question.
Will you explain to us what a fiduciary is? You can stand or sit, whatever you're comfortable
I'll
with.
sit.
Okay.
Basically, a fiduciary is one who manages and secures someone else's property, someone else's assets, takes care of them, and in some cases, in all cases, eventually distributes them to whoever they belong to, if someone's passed. So it's securing and holding and managing the assets of someone else.
Okay, great. Okay,
Can I just add something here? So some of your investment advisors are fiduciaries and some aren't. And the other thing that fiduciary means is I'm going to do the best I can for my client as opposed to good for my client, but better for me, right? Again, some financial advisors are fiduciaries. They're going to do the best they can for you. Is this the best that they have to offer you? As opposed to a non-fiduciary who is, this isn't the term, but is it appropriate for you? There's a difference between the best that I have or is it appropriate for you based on your experience and your net worth and your risk level and whatever. But the fees might be very high, so that's doing the best for the financial advisors. That's another facet of fiduciary.
so Megan, would you walk us through a typical process of administrating a trust? Kind of like from when it's created until it's terminated?
Well, from when it's created, usually, a fiduciary doesn't usually get involved initially. Fiduciary usually comes in when someone is deceased. As soon as someone dies, the fiduciary then takes over. Because typically most people manage their own trust while they're still alive. So once you've passed, that's when the fiduciary would take over and manage the assets. So what I do when I'm called is, first and foremost, I secure the assets. Oftentimes that involves real estate, a house. I would secure the house, make sure nobody can get in. Many times there are keys floating around there, or someone knows where there's a key, and that's a really big important first step for me as a fiduciary, is to secure the house. Make sure nobody can come in and take things, and it happens all the time. So securing the house, securing the assets, going to the bank, documenting with the bank and the financial companies who I am and that I have access and the right to take care of this property on behalf of the trust, on behalf of the beneficiary. I would then locate bills, find out what income comes in to the family or the person that I'm managing the estate for. Make sure that the bills are paid. Make sure if there's a funeral expense involved, make sure that's taken care of. I would collect information to be able to pay estate taxes or the final tax return. I would contact you. I usually try to stay with a CPA that the person has had for years, because they know the history and what's happening. So I would contact the CPA, I would contact the estate planning attorney and say, oftentimes I hear from the estate planning attorney first. That's how I would be notified. I would gather my team. Often we're referred to almost in a sense as quarterbacks. we would gather our team and we would manage the CPA and process the tax returns. We would manage the financial planner, make sure that all the assets are well protected according to California law, and contact a realtor if there's one needed, contact an appraiser. We usually have to have the assets appraised from the date of death forward. And then at that point, once everything is collected, then I work with the attorney to determine when and what is the best strategy to make distributions to the beneficiaries. Oftentimes it's families, younger, children and siblings, and the trust document then tells me and directs me how to do that. So I would make distributions, file the final tax returns, and then at one point I would hold a small amount in reserve to make sure that someone such as the IRS doesn't come back and say, hey, you still owe us a little more money. So there's usually a 2 or 3 year holding period according to a window of comeback from the IRS. So we would hold a small reserve, and at the end of that 3 year period, distribute the remaining assets to the beneficiaries.
So I have a question. Do people, when they're putting their trust together, do they hire you before they die? Or does a family member contact you like, I was supposed to be the trustee and it's way too much? And what kind of factors go into hiring a fiduciary?
So typically, a fiduciary is named like a licensed professional fiduciary is named as the successor trustee for the grantor or the settlor, the one who makes the trust. So I would typically be called and have a conversation with whoever is making the trust with the estate planning attorney. I would be named as successor trustee, and then often there's somebody, many times just in our own office, that would be a backup to the successor trustee. Or there might be a family member as a backup to the successor trustee.
So, because so often a family member is the trustee, and so there's, as Merv had mentioned, sometimes there's like conflict. Merv, maybe you can address that a bit. Like, what do you see the difference between like a family member, friend, and a fiduciary? What's the benefit one way or the other?
So, let's back up slightly. How do you select, and what are the options, right? I mean, what are the options? So, I always tell my clients there's two groups. There's family, close friend, other, right? Those are your two groups, right? So, who is the perfect person? Bob is the perfect person. Well, all right, here's the hypothetical perfect person. You tell me how close Bob is to it, right? So someone who's part attorney, part accountant, part financial planner. Well, 95% of the world is gone right there, including myself, so I'm not suggesting that you name me. Someone who everybody trusts. Well, that might knock out the sibling right there, right? Someone who everybody gets along with, which is what you're talking about. And someone who has done fairly well in life, so they're either retired or semi-retired. Because it's a family honor, but it's also a job. It's a job, and it takes time. And everybody says, oh, what is there to it? You go around to the bank and get the money and whatever. Have you ever had trouble getting money from the bank and having them recognize you as the official person? And every bank is different. That was a rhetorical question. and every bank is different, and seemingly every branch of every bank is different, and their viewpoints change from week to week. Okay, and the big banks are the worst. I hope I don't have a representative of a big box bank here. But in any case, it takes time. I was the fiduciary, the executor in probate for my uncle who died in the 90s sometime. And he had a bunch of accounts like I was relating before. And at the end of the line, I'm putting together a financial report. We call it a fiduciary accounting, because of course I want to see that, make sure that I didn't run off with the money. And I don't know, he had, let's say a $500,000 estate, I don't really remember. And I was $99,500 short. I said, oh, I'm going to jail. Where is it? Well, I finally found it over here. It was an account that I, sort of, I got mixed up with something else. But that's the job, right? There's a lot of job duties there, and it takes a lot of time. So if you have a job, you're not retired, you're not semi-retired, where exactly does that time come from? Right? Where does it come from? So now we're over to the other group, other. Other is a trust company, a professional fiduciary, that type of thing. A bank, which is a trust company, basically. Well, what are their advantages? Well, their advantages are, and this is what you were referring to before for the conflicts, they are not uninterested, but they are disinterested, right? In other words, they're not playing favorites. You got 3 kids, they're not going to play favorites because they don't care. They don't like Billy better than Bob, or Christy, or whoever. They don't care. They're going to be disinterested. They do this 1,000 times, right? 1,000 times every year, maybe 1,000 times a month for all I know. So they've got it down. I don't know what your occupations were when you were working, if some of you were still working, doesn't matter. But think about when you first started. Think about when you first started, okay? The first time you did anything, it took forever, right? It took forever. Second time was about half that, and the third time, you started having it down, right? That's seemingly how everything in the world works, right? Well, they've done it 1,000 times, so they've got it down. They've got the software, they've got the infrastructure. If something strange comes up, they know who to call, right? If they screw up, they have very deep pockets to collect out of. They've got insurance, they've got bonds, they've got all this type of stuff. If they take a vacation, there's always another fiduciary trust officer to step in. They charge. Yeah, you charge, don't you?
I do.
Okay, all right, so you charge. And all my family members are not going to charge, so it's going to be better. Well, if they come into my office and they say, I don't want to charge, it's just a family obligation, I'm going to say, by the time this is done, whatever you're paid, you're not going to think it's nearly enough. So you are going to charge, okay? So in other words, they're going to be equal at that level. So that's your 2 groups to choose from, and you got to make a choice one way or the other, and one has more potential for conflict than the other. Got time for a quick story?
I have a quick question first.
All right, go ahead.
Well, actually, a comment. So after talking to you the other day, my mom's trust, we probably really screwed up. Whoops, I don't have this on. So mom wanted me to be the trustee, and my brother was upset, my sister was upset, the other 2 don't care, and they don't want to do anything anyway. And so mom goes, how about if we do all 3? What do you think, Christina? I'm like, I don't know, I don't want Sharon and James mad at me. Okay, so now we have 3 trustees. And what did you say about that?
Oh boy. So my mom died about, 15 years ago, right? And, I did the trust for her, obviously. And she insisted, I've got 1 sibling, brother. She insisted that we both be co-managers, co-trustees, right? Mom, you don't want to do that, you don't want to do that. That's the way we're going to do it. Okay, well, it's kind of hard to argue with your mom, right? Okay, fine. So my brother and I were co-trustees when she passed. Now, my brother and I get along great. Complete opposites, but we get along great. He's an engineer type. That's his background. And obviously legal isn't his, so he backed off on almost everything. And allowed me to take control, which was fortunate. But I'll tell you another situation. I got a call a year ago, I guess. Mom and Dad died. Right? Mom and Dad died. We've got 4 siblings. I had written the trust, right? I hadn't seen them in 15 years. So here's the plug for getting your trust reviewed, right? They had purchased a life insurance policy in between the last time I talked to them and when they died. Right? Great, $500,000 policy. It was not in the trust, right? It paid 1/4 to each of them, right? We have a house in the trust. Never, ever separate the money from the assets, from the real estate. How do we fix it up for sale? Where does the money come from? How do we pay taxes? How do we do this? How do we do that? How do we keep the insurance in force, right? And these 4 kids don't get along, and 2 of them are absolutely nuts. But in any case, that's a separate story. And because they don't get along, no one's putting money in to keep this stuff going. So are they going to lose the house? I don't know. It's a good possibility. It's a good possibility. There was no money. No one wants to hire me. We actually had a bank named as a disaster trustee. No money, and 4 kids don't get along. Goodbye. I'm not interested, and I understood. So I hope that answers the question. Don't have co-fiduciaries. That's my opinion. That's not a legal opinion, okay? You line up 10 attorneys, you might get 3 who say, yeah, that's fine, and 7 who say no, or vice versa.
Based on time, let's move on to wills real quick. Merv, I'm gonna keep you talking here for a little bit. I have a question, you know, what is the point of having a will over a trust? And what if, like, a person, like, say they only have 15,000 in assets, or 100, you know, it's like something kind of simple. Would a will be advisable? I mean, like, when would you say do a will and not do a trust?
So, a couple things there. First off, when we do a trust, we always do a will also. And that's fairly standard for any other attorney I know anyway. Because there's usually, well, I mean, we don't put the furniture in the trust. I know some attorneys do, I think that's nuts. We don't put the furniture in the trust, we don't put the cars in the trust. So, you know, there has to be some kind of document that says who's gonna get it, right? So we typically will do both. But when would you not need a trust, okay?
Yeah.
You know, I think that you can make different bright line decisions on that. I'll tell you that somewhere around 180,000, it changes every year because it's tied to the cost of living, so I can never remember it. But somewhere around $180,000 is one break point, because if you have less than $180,000, there's a whole lot of things we don't even count. If you don't have a trust, you just have a will, there's not going to be a probate anyway. Basically, the California law says it's too small to worry about, just go. And all it takes, let's say you got the $170,000 in the bank, all it takes is you'd call it a letter, a 2-page letter, we call it an affidavit, and a death certificate, and you know, that's really all you need. I usually make the break point at $250 maybe, something like that. And, you know, did you know you can get a free will? How many people knew you could get a free will, huh? Okay. So there's what's called the state bar will, right? And you go to the state bar website, and there's a statutory will or something like that. For simple situations, I mean, don't try to make it complex. Yes, you got to follow the instructions. You got to read the instructions. But if you do that, you've got a valid will, and that's fine. There's various other places you can get all this stuff off the internet. You get a living trust off the internet. I'm not saying you should. I'm not saying it's going to solve your problems. I'm not going to say that it's not going to cause other problems, but you can do it. In the old days, I'd say you can go down to the bookstore. I don't know whether they still have bookstores, but you can go down to the bookstore, and for $19.99, you can get a book with living trust forms in it. You know, fine. But you're not getting any advice or recommendations. So, you know, if you want to do that, fine. And for, you know, you got $15,000, or you're not going to have living trust anyway, but you don't need all this complicated stuff. You need a really simple will, which if you're in a standard situation, the state bar will is going to do for you. You need a power of attorney for finances. You can get that for free off the internet. It's called the statutory power of attorney. So if you, California statutory power of attorney, if you plug that into the Google search box, you get a whole lot of results. Go to one of the law libraries. Don't go to a commercial outfit, right? Just go to one of the law libraries. I think the first one that always pops up for me is the Sacramento Law Library. And you can get that. From the California Medical Association, you can get, it's not free, it's going to cost you $15, big deal. I think that's for 2. You can get a power of attorney for medical, okay? Looks almost identical to mine. Theirs is pre-printed, mine pops out of the computer, because we both got it from the same source, which is the statute. So what else would you need? Will, power of attorney for finances, and power of attorney for medical care. You're done at $15,000. You might be done at $150,000, and you might even be done at $250,000. Oh my God, there's going to be a probate. Well, the probate is the concerns, the cost, the hassle of probate is directly related to how much of your assets have to go through probate, right? So have a pay on death bank account for your bank account, and get yourself down below $180,000, and we're done. 180 is approximate. I don't know what the real number is.
So 180 is kind of the magic number then?
For me, it's 250,
Okay.
300, yeah.
Yeah, so, okay, so you, you have the bank account, like the pay on death, what about like a car or other type of thing?
Cars by themselves will never, ever cause a probate. If there is a probate, they might have to go through probate with it. But if you've got a car, it's not going through probate, which is why I never put it in the trust. That's not true. I made one exception. He had a $150,000 collector's Mercedes-Benz. I said, okay, I know what the rules are, that's going into trust anyway. Are we taking questions now or not? No.
No questions yet.
No questions yet.
Okay, so how often should a will or trust be updated?
Okay.
And why?
Before I get to that, let's talk about
Okay.
what isn't counted for that $180,000 or so
Yes.
magic figure.
Okay.
Cars aren't counted. Mobile homes. Mobile homes aren't counted if they're registered with HCD, which is the equivalent of DMV.
Boats?
Boats, if they're registered with DMV or whoever they're registered with, they're not going to be counted. Furniture isn't counted because no one cares, right? No one cares. Anything that doesn't have a title on it, you don't have to transfer title, right? So the coin collection, that's might be worth tens of thousands of dollars, but it's not really counted. Salary that's owed isn't counted. A whole bunch of things aren't counted that we just don't even worry about when we're calculating, are we over 180 or are we not? That's sort of how that's anything that's pay on death, anything that's transfer on death, anything that's joint tenancy, anything that's in the trust. There's probably a few others I've missed, but basically, life insurance with anything with a beneficiary on it, life insurance, IRAs, anything like that, they're not counted.
Okay, update. When do you update a will or a trust?
Updates, okay. So I like this, I'm gonna sit, okay. I like to say, when things change, it's time to review. Oh, well, nothing's changed. Did your health change? Oh yeah. Did your wealth change, either up or down? Oh, yeah. Did the kids change? Oh yeah, Bobby is really out there now. Those are changes. Oh, but I was only talking about whether the law changed. Who cares? 99% of the time, you don't care, right? And I see all these law firms that, you pay me $150 and I'll send you the updates each year. Never talk to you, but I'll send you all these updates each year. Who cares? Okay, now, there is an exception to the who cares rule there, and that's powers of attorney for finances and big banks, right? Any bank, maybe. They hate lawyer-drawn powers of attorney, and they look around for reasons that they don't have to recognize them. They want it on their own form. Of course, their own form is, it's nowhere near covers the things that a typical lawyer-drawn one will. So we tend to want those updated, whether there's been a change or not, every, 3, 4, 5, 6, 7 years, anything like that. We probably want that updated just to eliminate that as a problem when you have that stroke. Hope you don't, but when you have that stroke, your daughter goes into the bank because she's named in the power of attorney as the first holder of the power, and you don't want her to have problems to get access to the money, to get them to recognize your authority, which is what you were talking about before. So we want that updated, but the trust, medical power of attorney, we want that updated. Anytime you go into Scripps Hospital or any other hospital, they always ask you, well, do you have a healthcare directive, a healthcare proxy, a power of attorney for healthcare? 3 different names, same thing, okay. Okay, well, we'd like a copy. Why is that? Oh, just in case. So, if it's 1 day old, they're tickled pink, right? If it's 99 years old, they don't feel so comfortable with it, right? So it should be updated. When? I don't know, every 3, 4, 5, 6, 7 years, something like that. Yeah.
And one last question before I ask Megan some. What happens if someone dies without a will?
You died without a will. Oh my God, he died without a will. Is that a problem? Sometimes, not always. The first thing is, who is going to inherit from him? Doesn't have a will, doesn't have a trust, and let's say he doesn't have any POD accounts or beneficiaries or anything. He's got $500,000 in the bank, and it's just his name, right? No joint ownership, nothing. It's going to go to his closest relative, what is often referred to as next of kin, although I've never found a definition of what that means. So it's the closest relative, which is defined by state law, right? And in most cases, it's exactly who you think it would be. It's your spouse, it's your kids. You don't have any of those, and maybe it's your siblings. I mean, it's right there, and you just go down the line. I mean, that's what I do. Okay, doesn't have any of those. Okay, doesn't have any of those. That's who inherits. Once we've decided that that's who's going to inherit, now we sort of have to decide, how are you going to inherit? Are you going to inherit through probate, or are you going to inherit outside of probate? Probate is a court proceeding. Outside of probate is not a court proceeding. If you have a trust and that bank account title was held in the trust, you're probably not going to court, okay? Now, it's not that big of a difference. Everybody says, oh my God, the probate system, it's awful. They're going to take all the money and it's going to take 3 years, right? How many people have heard 3 years, right? Just me? You did, okay. You're the only one who got to raise your hand. Okay. So, over the years, I mean, we call it a state settlement, both of them. It's a settlement, right? The out-of-court settlement process is very, very similar to the in-court probate process. We have to notify the same people. We have to deal with the same taxing authorities. We have to deal with the same beneficiaries. We have to notify the same people. We're dealing with the same assets. Everything is the same except that we don't have to go to court, okay? So what does it mean to go to court in a simple probate? Now, let's start off with, how long does a simple probate take? Well, it takes 10 to 14 months. That's what it takes. 10 to 14 months. Why would it? Well, first of all, that's less than 2 years, right? And second of all, because your person wasn't the only one who died in San Diego County. So get in line, right? Get in line. And the first thing is, you got to file your papers with the court to start it. And it's going to take 6 to 8 weeks for your hearing date to come out. You're not going to get it tomorrow. And you got to notify people and publish in the paper and do those things anyway, right? And then, after you have that first court hearing and they appoint you as the executor, I guess, the administrator in this case, the manager, now you're going to marshal the assets, identify and gather the assets. You're going to get them valued, appraised. You're going to deal with the tax authority. You do all these things. You're going to notify creditors, right? And that's a 4-month process to notify creditors minimum. So just keep it adding in your head as to how long it takes. Now you're ready to go back to court. We're ready to distribute, right? Okay, well, get in line. 8 to 10 weeks to get your hearing. Now you get your hearing, and the court says, gavel comes down on the bench and says, okay, it's going to be distributed just like you wanted, counsel. Take your order. And then you go through distribution. So I don't know what the minimum was, but in my uncle's case, where we're going through probate, I hired an attorney because I wasn't getting along so well with my cousins, who were also part beneficiaries on that estate. So I hired an attorney. So we have 2 attorneys now, right? How long did it take? I mean, you would think that would, be going like clockwork. 10 to 14 months is what it took. I think it took 11 months. So how long is a trust settlement going to take? It's not going to be 30 minutes, and I have heard speakers say, 30 minutes if you have a trust. I don't know what state you live in. So the minimum settlement period with a trust in California by law is 4 months. You distribute it early between 2 brothers, who's going to care, I guess, but nevertheless, statutorily, that's it, minimum 4 months. So, I usually say 4 to 6 months on most trust settlements if we have more than one beneficiary. If it's one kid, then that gets pretty simple. How much is it going to cost? Because I know that's going to be the next question. Probate is a statutory fee. You look at the statute. If you look on my website, I'll give you the statute number, link, you can go right there. It's a complicated formula. Basically, it's, what is it, I don't know, 2% plus $3,000 on the first million, and then, it goes down, right? So $23,000 on the first million. And that's what it costs. A trust is going to be somewhat less. It's not going to be free. Not going to be free because a lot of work there, a lot of responsibility. Pretty much the same work, but it's gonna be a little bit less iteration and a little bit less in cost generally, okay?
So Megan, when there's a will, so what kind of duties do you find yourself doing involved with a will as opposed to a trust? Is there different types of duties that you're doing?
Typically, when there's a will and a trust, usually the will pours over into the trust, so there's really not that much that coincides with managing a will versus the trust. When in all the work that I've done, I've had both the will and the trust named with me, and everything is done via the trust at that point. The will, everything that is in the will pours into the trust. So there's really not that much difference as far as managing a will versus a trust. As a fiduciary, I have not received a matter where it's just been a will.
Okay. And so as the executor of a will or a trust, you're having to deal with a lot of the beneficiaries. Is that difficult? Because there's probably often a lot of them. It's like, do you have to talk to each of them, or what do you do?
Absolutely, yes. I have a duty to reach out and communicate with the beneficiaries and coordinate with them. It's not always easy, as you can imagine. Many times a fiduciary is named in the trust because family members have conflict. Their siblings don't get along. It's a really common thing. And not only for managing the conflict between the beneficiaries, but also, even if there isn't any conflict, I'm often engaged as a fiduciary so that there never will be a conflict. Often parents want their siblings or their children as siblings to have and maintain their good relationships that they have now. And oddly enough, when money is involved, after their parents pass, conflicts happen immediately.
Unfortunately, that often happens when money and assets are involved. We're going to quickly move on to guardianships and conservationships. And we're not going to spend a lot of time. When I came up with the topic, I thought it was more relevant than it is. Will you share a bit about where things are at? It's like it's just not as used as much anymore. Is that true?
So, conservatorships and guardianships. Guardianships are for minors, 18 and under. Conservatorships are for anybody else who can't handle their, let's say, financial affairs. So let's just call it all conservatorship. There are conservatorships of the person, and there are conservatorships of the estate. Of the person, where do you live, what kind of care do you get, medical care, that type of stuff. Of the estate, management of the assets, basically. Some people have described it as a living probate. And everybody says, oh, probate, I don't want that. Well, how would you like to have a living probate? So basically, you've got to file financial reports with the probate. You've got to file financial reports with the conservatorship, with the court. And that's got to be done every other year. So you got a court hearing. Well, you got a court hearing. There's an attorney involved, right? Attorney charges, and he does. Putting together the financial report, there's a charge for that. It's not free. So you want to do anything out of the most basic investing, which means an FDIC insured bank account, you probably have to get court authority for that. So we like to avoid the necessity of a conservatorship if we can help it. And living trust, I mean, that's one of the ways of doing that. If we have all of our assets, and I don't really mean all, I don't mean the car, I don't mean the furniture, etc. But if we have all of our assets in the living trust, you can't handle your financial affairs anymore. Well, the successor trustee just funnels in, basically, and takes control of the assets and starts managing it without court involvement. And like I said, I mean, anything you do with the trust, you can do other ways. You can just do more things at the same time with the trust. than you can with these other things. So, I mean, a power of attorney would do that too. So in a smaller estate, that $200,000 estate, we might not have a trust, but we're gonna have a power of attorney for finances. Because again, we don't want to have the necessity of having a conservatorship. I don't actually handle conservatorships. I haven't handled them in probably 30 years, but I handle avoiding them. So I mean, if a conservatorship is necessary, I have people to call, but you know, it's not something I myself handle, and most people, but most attorneys, I guess, would say better to avoid it, better to create the documentation to avoid it so that we don't have to deal with it later.
So we have a lot of other questions, but based on time, what I'm going to do is ask both of you if there's anything that we didn't touch on that we should have. Would one of you like to start on that?
I guess I will.
Okay.
So, you know, this probably seems like a very smooth operation to you. We've talked a few times about this, so this isn't something we put together in 2 minutes, but you know, one of the things that we talked about was, what are some of the disasters you've seen that if it had been done right, you know, you could have avoided, right? And I was telling you at the opening about, I don't know, the 56 different accounts and the 30 different financial institutions or whatever, so let me tell you that story. These people have been clients of mine since the early 1990s, right? And I said, well, we should have a living trust because, you know, you're worth more than that break point, and you know, you don't want your kids to have to deal with probate and this, that, and whatever. And, no, just want a will. You're sure? Yeah, just want a will. Okay, fine. So between then and I think 2022, I saw them twice, right? They came back for reviews twice. I think you should have a trust. No, we just want a will, we're happy with the will. You know, and that happened twice. Well, I mean, you know, it's the client's choice, it's not my choice, right? So the wife dies in 2022, right? And the other worth, I don't know, $2.5 million. And that includes some real estate in Carlsbad, which is all in her name. Actually, she owns half of it with her sister, but the husband's name isn't on it, right? Okay, so she dies, you know, I'm talking to the husband. You know, I think I should have a trust. Okay, a little late, but okay, let's do that, right? Now, he's not in the greatest health, so we're kind of in rush mode, right? So we put together the trust, and one of the daughters is now, you know, helping him run around to Bank of America, Wells Fargo, and Chase, and Fidelity, and, you know, all these different financial institutions, ones I've never heard of, too, to try to get title into the living trust, right? Well, he dies a month later, maybe, right? I mean, we don't get everything in. We don't get nearly everything in. So now we've got to get title to everything and divvied up to all of the kids. Except it's not quite that simple. He insists, there's 5 kids. He insisted that, and a blended family, okay? So 3 kids and 2 kids, something like that. He wanted to leave, I think it was $15,000 to each of the grandkids. All right. 13 grandkids. Now, you were asking a little before, someone was talking a little bit about, you got to notify all these people and deal with them, and how do you deal with all of them, and whatever. Well, we have to notify them all, right? So we got to get addresses. Most of the grandkids we have addresses for, from, you know, the kids. 2 of them are in prison. One of them, no one knows where he lives. They see him every once in a while, but they don't know where he lives. Right? So how do we deal with that, right? And when you're in prison, that brings in other procedures that we have to deal with. And the house. Well, remember, that was all in the wife's name. She died first, right? Well, her will left everything to the husband. He left everything to her, obviously. We have to get title from her to him. We don't have a trust to do that with. So we need to go to court. Now, it's what I would call a mini probate. There's an official name for it, but it's a mini probate, okay? Simplified probate. But we have to go through the process. We finally get that. Now we have to get it from him to his trust, right? Well, we're gonna need a full probate for that, along with all the other assets, right? So this is, without question, the most difficult estate settlement I've dealt with in my 40-plus years of practice. Not the largest in net worth, but just having so many things to deal with. Well, so what is the takeaway here? One, a trust would have been a really good idea here, right? Way back in 1994 or whatever it was. It would have been a really good idea. Two, you don't need to deal with 26 different institutions, financial institutions. You're not getting any benefit from it. Oh, no, okay, I'm sorry. Maybe you got the coffee maker, I'm not sure. But you don't need to do that, and that is just going to create hell for those who are coming later to clean up the loose ends, right? And then we have to send out financial reports periodically, right? There are 13 grandkids that have to be included, right, in this mail out. And, let's assume half of them are married, right? So now we've got 8 spouses. So we've got, 13 and 8, 21 different people, any one of whom can say, that $20 charge there? I don't think that was valid. Give me the backup documentation. Again, I'm exaggerating, but that can happen. So the more people you're dealing with, the more possibility for objection on grounds that are, out there, right? Is that what you want? And even if there are no objections, there's just more people that we have to deal with, which makes it more complex, which means I'm spending more time, which means, come on, you know what the answer is. It's going to cost more, right? It's going to cost more. So, those are the 2 big takeaways from that one, I think.
Thank you, Barb. Megan, do you have something to share before we close out?
Yes, so I think we have not talked about, maybe everybody should have, what would make my job easier when someone has died is if there was a document that was with their estate planning package that would list usernames and passwords, obviously kept secure in a very safe place, but who do we contact? Who are the children, their addresses, their phone numbers, their email addresses? What banks are involved? What financial institutions? What credit cards do you have? It would save so much time for me to have a single document to go to and go, okay, I'm going to Wells Fargo Bank and Bank of America, and that's all I need to do. I don't need to try to search for more documents within drawers or files or in the garage or in the attic. And that's what I often have to do to find out where are all the assets. If I had a single document, it would help. And I did bring like a little organizer. I had no idea there were going to be so many people here, so I brought 10. I'm so sorry. I will leave the 10 that I have on the table, but there's my business card over there, and I will be happy to email or mail a copy to anyone that would like one. And not all the information within that package would apply to everyone, but it's for a general purpose, like in case somebody has this or that or the other, and it would list.
Megan, thank you. That's really generous of you. We're going to do question and answers. Yes, you can talk because I'm in that period. And we have a microphone up here. We're going to do Q&A now. So yeah, go ahead and say something while they get the microphones.
So, what Megan's talking about, we encourage clients to have what I call an asset locator chart. Problem is that you have to keep it updated. I mean, that's because you change banks, right? You change this, you change that. Password managers, so my daughter has the access code to my password manager, type of thing, because that's kind of important. Great, you have a password manager, but no one has a password to get into password manager, right? Or, you write it out, well, where is it, right? Where is it? So, all of these things are important. I've got a handout out there, too, about the recent change on Medi-Cal and the fact that it's no longer net worth based. you can be worth $5 billion and you can qualify for Medi-Cal. You might not want to. You know, there's all sorts of ins and outs to that, but you know, in theory, you could do that.
So please raise your hand if you have a question for Megan or for Merv. Does anyone? Yep.
I have a question.
Yes.
I have a question for you. Is it true that you have to pay back your last Social Security payment in the month that you passed away?
Well, I believe that if you pass away, my understanding is if you die in the middle of January, you're gonna keep your January payment. You will not get your February payment. If Social Security has not been notified before February, before your next payment is due, yes, it will be pulled back.
Okay, I'm gonna just disagree on that, I think.
Okay.
Because it's, yeah, you know, I mean, this isn't the biggest thing in the world, so neither one of us are gonna have that on top of our head. But I believe you have to survive to the end of the month, and if you don't, they will reach into the account and pull it back. Which again, you know, I mean.
Do they take like the whole month or like 50
It
days or
is-
whatever?
It is not prorated.
It's not prorated.
Not prorated, so, for me, I get my check on the, what is it, 26th or something like that. I mean, no one gets checks anymore, you know, it's dumped into your account, but I get it on the 26th so if, what is this, August, so I'll get it on August 26th for August, right? So I gotta survive till through the 31st, I guess, or, you know, okay, you know, again, not the biggest thing in the world, but, you know.
Yeah, it's something
It's a thorn in your side.
Okay, raise your hand if you have a question. There's gonna be one up here, Chris, afterwards. Wait, there's somebody over here, then you'll come next.
Yeah, I have a question about these services through like credit unions or whatever on doing, it's called legal karma, and they'll do, you know, a trust or whatever online, and it's like a flat fee. So I just want your opinion about that.
I've never looked at it, although I have seen, you know, other, I'm not familiar with that firm, let's put it that way. Bottom line is, if you've got $200,000, you don't have a complicated situation, number one, did you need a living trust in the first place? And number two, you know, maybe it'll be sufficient. You're not getting any advice, so, you know, who should be, so what kind of advice are we talking about? Who should be the manager? Who should be the manager? I mean, I talked about that a little bit before. I had a client a number of years ago who had 7 kids. 7 kids, okay. Said, who do you want to be the manager? I want Bob to be the manager. Why do you want Bob to be the manager? Well, because he's really good with numbers, he's really good with books. We talked a little bit about that. It turned out that he had been in jail for cooking the books. I said, well, probably not the best choice. You know, I think you probably could figure that one out on your own, but this lady couldn't. How do you want to distribute? Do you really want $15,000 to 13 different grandkids? Do you want to leave $5,000 to 15 different charities? That's not a good idea either for various reasons. We won't get into that because we don't have time. So all of these things that, you know, you're thinking of doing or you haven't even thought of, we can leave an inheritance to the kids in 2 different ways, adult kids. We can leave it into their pocket. Here, honey, have a good time. I love you. Or we can leave it in the form of a trust. Why would we leave it in the form of a trust, irrevocable trust, for the kids after we're gone? Well, what about divorce? What about lawsuit? Well, you know, this can rip away half all of their inheritance. We can protect it for them. Now, you're not going to do that with a $50,000 inheritance, because that doesn't make sense. You know, again, maybe $300,000 leaving to that kid, you know, and that kid, 3. So, you know, all of these things are things that is worth discussing with someone to get some advice and recommendations. The value of an attorney is not that he can put together a pretty-looking document. They're all pretty-looking documents. From whoever you just were talking about, I'm sure that'll be a pretty-looking document. The question is, will it work when the rubber meets the road? And the rubber meets the road one of two times, when you lose mental competence or when you die. Other than that, no one cares what you have in that document. The court doesn't care, the state doesn't care, I don't care, no one cares, okay? But one of those two times, then it becomes important. And if you didn't have advice, okay, well then you didn't have advice. So that's fine.
So you have one more there, and then we have one up here. Go ahead.
Yeah, we have a family member that died during COVID and left the estate in a trust, but not a conservative trust. Left it to, the two beneficiaries are a single mom with special education, mental disabilities, and the daughter who's also a special education minor. And the trustee has been financially abusing them and, mentally abusing them in many different ways. But the young adult mother is too incompetent or incapacitated to fight to get any help. And the other child's a minor. For example, he took the child and put the child, he had the mother sign off for her and the child for a piece of real estate. And then he sold it on a quick sale. Then he also had the child, he decided to put the child in a boarding school in a different state, like thousands of miles away from their mother, and he's done really crazy stuff. Well, they know what the question is. What do you do? They know what can an outsider do in that situation, because the mother won't go and say, this trustee is dangerous to me now. Or has been, he has no accounting of the money, she's never received an asset liability thing after the death. There's been no help whatsoever.
Megan, do you have some thoughts on that?
Well, my first thought is, has Adult Protective Services been contacted? And if they have not, I think they should get involved.
Well, the neighbors did, some of the neighbors are attorneys, and they have gone to her, or she has gone to them, and they have said, you need to get some help. Here's a fiduciary you can trust, go make an appointment, go see this fiduciary. I'm an attorney, but I don't do litigation, I just write papers, so I can't litigate for you. There has been neighbors that have stood up. She just keeps going back to that same guy. He's paying my bills, my credit card every month. Calls her drunk half the time, but he's paying my bills. She's not at that level where you're talking about.
It sounds like she has a fiduciary, so,
No.
No?
She has a trustee that was put into a non-conservative, non-guardianship trust, and has to deal with this trustee who, took it through probate.
Okay.
She never received an act. She doesn't
So-
know what she inherited, because she never received an
Okay.
asset sheet.
Okay.
They know what I'm talking about. You don't.
So, Adult Protective Service would be one approach, which apparently was tried and failed. Next would be, from the description that you're giving, it sounds like money is being stolen. That's what it sounds like.
Yeah, right.
So that should be referred to the district attorney, who also works with Adult Protective Services, but that's probably where I would go on that. But I don't want to get into a specific situation, because that's more than one.
Okay, we're gonna go into the next one.
Is there one question, is there a trustee code of behavior?
I think I understood
law?
that.
We're gonna move on, and, if you want, we can get you the district attorney's contact information. Okay.
Okay, I think I understood that the typical cost for an attorney is about 2% of the whatever you call it. What's the typical cost for a fiduciary?
So I work by the hour. A lot of fiduciaries work by percentage of assets. I work by the hour. My current fee is $225 an hour. I do not work on a percentage basis. So most corporate trustees, such as the banks, they work on a percentage of assets. Depending, I find for most of the matters that I've known about and been involved, most of them are, the fees end up being less expensive by the hour. Of course, that depends on the size of the trust.
The only thing I would say, as to your question, is 2% had to do with probate, okay? Had to do with probate on the first $1 million, All right, it doesn't have to do with anything else.
Any other questions? Yes.
Hi.
Hi.
I would like to know if your beneficiary for the bank supersedes the will or the trust.
Say that again, I'm not sure I understood it.
Maybe I'm not explaining it right.
Oh, the beneficiary, okay. So if you have a bank account with a POD beneficiary, Jane, but the trust says everything goes to Mary, is that the situation you're inquiring about, that type of thing?
Well, if you have your beneficiaries with your bank,
Okay, so you
and
think,
you have a will, and which one
which
goes
one
first?
trumps the other?
Yeah, which one?
Okay, so the beneficiary designation trumps the will, as does a joint tenancy trumping the will, or the trust. Yeah, so that's the answer, yeah.
So, okay, really quickly, because we're coming to a close here. This will be the last question.
Well, we have a fiduciary who is helpful and we're married, and my understanding is that if one of us dies, that person who's the fiduciary will help the other one to make sure that things happen as they should, and help the surviving person of the couple to manage the next stage.
That's your question.
So a question or just a statement?
I was told that, is that what you understand?
You're just confirming?
That's your particular fiduciary.
Okay.
Okay, I'm gonna bring this to a close. Please, remember to fill out the yellow feedback forms. I'll have Harriet up here to collect them. I really appreciate it. I think we should give the panel a hand and thank them for their